My name is David Singleton. I am an attorney here in Fort Wayne, Indiana. I practice personal injury law, and most of my work is research and writing. So I do have a undergraduate degree in history, so I'm familiar with the research aspect, but I'm not a genealogist myself. So if you guys do have specific questions for things you've run into, those are things we can discuss towards the end of this. Most of what we're going to discuss today is kind of how courts are set up and general legal terms. Now, some of these terms are going to be sometimes Indiana specific. However, for the most part, they will apply broadly throughout the United States and really in any sort of jurisdiction that has any sort of British common law history. So to start here, let me pull PowerPoint. So legalese, unfortunately, we're plagued by it. There is a nice push recently, especially throughout the United States, to try and take away the unnecessary complication that our legal dictionary has, our lexicon. But for what you guys are all doing, you're still going to be stuck with the bad stuff. So a little bit of my background: I used School of Law in Indianapolis. Did my undergraduate at Palm Beach Atlantic University. Props to you if you even know where that is, other than in West Palm, obviously. I work now at Blackburn Green, been here for about 5 years, and what I do is motion practice, appellate law, and again, research writing. So let's get into it. And first things first, obviously, you need to know where you're going to start searching. I'm sure everybody's run into some trouble, and you probably will get confused about what courts you're even looking at. So over time, the names of the courts have changed in every single state. I'm just going to run through Indiana because obviously I can't tell you what all 50 states have done with their different court names, although I will do a contrasting in a few minutes with what New York State does compared to what Indiana does, just so you get a feel for how different things can be depending on which state you're in. Now, to start with, clear back when we were a territory, you had a bunch of different court names. You would have, first of all, the General Quarter Session of the Peace. They like to make things as formal as possible. That would do criminal, county administrative matters. So that was in 3 different counties where that first started. Started in Knox, Clark, Dearborn, kind of grew. Now, when we say Knox County, I'm sure many of you know that was about 80% of the state for a while. So including up to the time we became a state. So when you see a lot of stuff from Knox County, it's not just from Knox County like you think of. So that's something you have to think about is just because it says maybe Knox County for an old record, it could actually be somewhere, a few hundred miles from Knox County even, because the boundary lines will have changed over time. Okay, the legal boundaries for all of these, even for towns and things like that, have changed. So you need to be careful that you're looking at specifically, okay, where should I be looking and what was it actually called back then? So we have different things throughout the time as we were still in a territory. We had circuit courts. We had Court of Common Pleas. That is something that a lot of states used that term. However, most have gotten rid of it as a distinction for civil cases. Some states like Ohio will still use it, but for the most part, it's fallen out of favor. But as we go through here, it morphs over time. So we early on do get what's called a circuit court, and that's actually the term that's still used today, but there was some waffling and again back and forth with what courts were called. So you might see something from a circuit court in one time period, and then all of a sudden, 30 years later, you see, well, wait a second, here's that Court of Common Pleas again. I thought that was gone. Well, no, they brought it back for a little bit. But then everything reverts back to circuit, and that's where we're going to stay. Now, superior courts You might think, oh, well, that's a higher court. Realistically, it's actually a lower, usually equal to, but they're the second court created in a county. So the reason superior courts get created is as more and more cases come in, the judge doesn't have, you have a circuit court judge, he doesn't have enough time for everything, or she doesn't have enough time for all of this. So you had to start creating superior courts, which were side by side court handle cases, usually the same types of cases a circuit court would handle, just to take some of the load off. So in each county in this state, you have a circuit court. There are, however, some counties that don't have superior courts, and that's just because they don't have the need for it. The caseload just isn't there for those real small counties or small populations. So when you're looking through, there's sometimes no rhyme or reason as to where stuff is filed. Steuben County, I actually just had two cases filed related to the same incident. One got filed in circuit, the other got filed in superior. It's just where they decided to throw them when we filed them. The court there decided. Some courts, some counties will let you choose where to put them, but for the most part, the court designates, or the clerk will designate clerk of the courts where it's supposed to go. But now, shifting over from locations, real quick, we'll just take a look at a map here. Indiana 1816. Remember I mentioned Knox County? Boom, there it is, that green. If you can't see this very well, again, this PowerPoint will be made available for you later, or at least this graphic Allison will make sure everybody gets. So you'll see these boundaries for these counties, they're completely different, besides Knox, than what you will see today. So again, just because you see Jefferson or Washington or Knox, make sure you're checking to see, well, what actual area did that cover at the time? All right. So here is a breakdown kind of flow chart. Now, this may be kind of small for everybody to see. The links are, however, in the handout, I'm told. So you will be able to pull this up. This is really just so you have initially kind of some examples of what types of courts there are. So when you're looking through, you have, okay, I'm looking for maybe this type of record. I should reference, a specific court. Now, most court records, though, regardless of where they're at, are going to be with the county courthouse, county clerk, or they can direct you in the right direction. So even if it is in a, say, superior or circuit or probate, those will all be still gathered by the clerk of the courts. You do, of course, run the risk, like anything else, where you're looking for primary sources. A lot of these documents only have one copy, and fires happen, floods happen. There actually are some counties that lost almost all of their records. And I know one name escapes me which one, but at least one county in the state lost pretty much everything prior to 1970 in a fire. So be aware of that as well. You might go to a county clerk and they say, sorry, we just don't have anything. Now, as far as the breakdown of how the court system works, so you know basically what level you're at, you do have small claims courts and things like that. Those are still a little newer, so you're not really going to see some old records involving that stuff. Most of what you're going to see is going to be in the circuit court, superior court, court of common pleas, things like that. Those are your first level courts. Okay, if you're filing a brand new case, if I'm filing a lawsuit, I file it into circuit or superior court. If I need to do something with an estate or do a guardianship for a child, I file that with the probate court. Now, in Indiana, the probate court's actually a division of the circuit or superior court. So it's not really its own court per se, but it's something that they basically will put a different name on the caption. The probate court judge could be the circuit court judge, and they just say it's probate court because of the type of case it is versus it being a different courtroom, different judge, something like that. Next up, you have an appeal. Appellate records are very well maintained. So if you do need, or you happen to get lucky enough that one of the things you're looking for would be in an appellate record, you have a family member there, you're going to be able to find those much more than having to hunt down by county. So the state does maintain those. Anybody can appeal to the Court of Appeals. Okay, that's true today as well. That's a right you have if you don't like the decision at the Superior Circuit Court. However, if you don't like the decision at the Court of Appeals, our Supreme Court, and almost, if not all Supreme Courts in the United States, will have discretion whether or not they accept. So there are a lot of cases where they ask the Supreme Court of Indiana to take a look at the case and say, hey, can you give us a ruling instead? Maybe 5 to 10% actually ever get reviewed by the Supreme Court. A much, much lower percentage by the U.S. Supreme Court. They're also discretionary, filing for cert, whether or not they take that. So pretty easy breakdown. You have your initial courts, your appellate court, your Supreme Court. Well, let's switch over to New York just as an example of how confusing this can be. New York, a lot more courts, a lot more places to look. Now, realistically, everything kind of in the bottom half of this flow chart, they're kind of specialized and really sort of niche areas. Okay, if you're going into what would be the typical court, let's say the circuit court in Indiana, well, here's for confusion, that's the Supreme Court in New York. So the Supreme Court in New York is the lower court. Now, if we go above that, that's when we actually get into the appellate division. That's like the Indiana Court of Appeals, so that kind of makes sense. You're appealing up, but their high court, their Supreme Court equivalent is called the Court of Appeals. New York's one of, if not the only state that has a hierarchy like that. Almost every other state will have Supreme Court, Court of Appeals. Keep it very simple as to what each of those are within a hierarchy. But that's just to say, when you're going to each specific state, you need to know what sort of court you're dealing with, because you might think you know what level of court it is, but if you're thinking, oh, I have the highest possible decision, I have the Supreme Court of New York, well, that's just a judge from a lower court, so be aware of that. Black's Law. Now, interestingly, you may have heard of black letter law has nothing to do with Black's Law Dictionary. So it just so happens that the fellow who wrote the dictionary, his name was Black, Henry Campbell Black. First published in 1891. It was the kind of first of its kind to really focus on general terms that are used in the law and how to define those. It's come to be a staple. Now, it's not controlling in any jurisdiction, but most courts, if they need to interpret what a word means, will look to Black's Law for some guidance on that. We are now in the 11th edition of Black's Law Dictionary. Great reference for you. If you don't know a term, if I don't go over something, or if it's just down the road, you find something, you say, what the heck is this? Go to Black's Law Dictionary, and especially try to find an edition near the time that you are researching. So if you find a term in something from 1899, well, pull out first edition Black's Law Dictionary where you can find it, and that will be more accurate for whatever term you're looking up. Although the newer versions do have references to sort of the archaic meanings for any of them, it'll be much easier, obviously, to go to something that was contemporary. I'm going to run through some terms here. If you don't understand something, or if you would like some more explanation on any of these, please just let me know through the chat. We'll discuss this afterwards. Most of you are going to know some or a lot of these terms already. We're running through this again as a crash course, so just bear with me. Some of these may seem obvious, but they're not to everyone. Now, common law is judge-created law or tradition-created law. This is prevalent and found in every single former British colony, because Britain is a country of common law. What that just means is, as each case gets decided, starting way back to the time of the king, as cases are decided, the law is formed versus it being voted on by a legislature. So, interestingly, this is why the U.S. Constitution was actually very unique. Was it was creating a set of uh, rules, laws, effectively in written form. Uh, it was the only precedent beyond that would have been, Magna Carta clear back before that. So, uh, but that's where common law comes in. Uh, you have two different courts going back historically, court of law and the court of equity or court of chancery. So the court of law is what everything's combined under now. We have courts of law. But back in uh, older times, it would be handling criminal matters or items of damages. Damages is a term that's used for money to be paid out. So, how much were you hurt? Here's some financial remuneration for that. So, court of equity, on the other hand, is what was fair? What is equitable? So, what they're concerned more is in the specific case, what's the right thing to do? And what that means is the court would order a party to do or not to do something. Uh, think of it like an injunction for today. So, an injunction is literally a court saying you can or can't do something. That's something that originally would have been done by the Court of Chancery or Court of Equity. Statutory law is where we've gone over the last 100 years or so. Rather than being mostly common law, our legislatures across the country and in the federal government have been creating more and more and more and more and more and more statutes, which unfortunately has really bogged down the legal system. It's created a situation, just on a high horse here, it's created a situation where nobody can really know the law. You have bills that are 20,000 pages long on a single issue. There's really no way to wade through even a single bill like that and really truly know everything in it. But that's what we have to deal with. Now, what that means is, as we're controlled more by statute, it's much more rigid and there's less discretion judiciary. So the common law still applies to areas like where I practice, which is tort law or based in negligence, harm to somebody else. And that's still a common law issue. But even then, we're seeing encroachment kind of changing the rules from legislative statutes. One statute, and this is a very common one, applies to every type of case. It's called a statute of limitations. So if you're looking at a document and a case gets dismissed and it says something about a statute of limitation, well, that's the deadline anybody has to actually file their lawsuit, to bring their claim. So if a statute has run, doesn't matter how great your case is, the court will just say, sorry, you're too late. You should have done it sooner. 2 years is pretty common, but it varies. If it's on a contract, it can be 6 to 10 years. Could be 1 year, depending on your jurisdiction, for a car accident. It could be any number of things. So, but that's going to be specific both to jurisdiction, which state you're in, and the time period that you're in, because those being statute can be changed by the legislature at will. An appeal, I've already kind of run through. That's just asking the higher court to review something. Simple. Transfer is when you're seeking a high court, in Indiana, the Supreme Court, to take over jurisdiction of the case from the Court of Appeals. Now, it's called seeking cert or certiorari to the U.S. Supreme Court and in certain other states, but basically it's just, hey, will you please accept jurisdiction, because they don't, again, we talked about that discretionary, they don't have to. Now, a writ, you're not going to see these a lot these days, but you definitely are as you do your research further and further back. Terms much more common. You all, I'm sure, have heard of the writ of habeas corpus and Lincoln's infamous suspension during the Civil War. That just means it's a challenge of the government's right to hold somebody.
literally give up the body. They're saying they should be released. But you'll also run into all sorts of different other types of writs. What those really are is the court commanding something. So even today, you might have what's called a writ of attachment, where a specific piece of property is seized even in order to pay a debtor because it's owned by somebody else or something like that. But those will still be used. When you see them, my best advice is look it up in the Black's Law Dictionary, because a lot of the writs don't even exist anymore today, but you're going to see them in older research. So that's where looking at an earlier edition of Black's Law will be very, very helpful. If you run into something called an affidavit, that's just a piece of paper person signs under oath, under penalties of perjury, and they're saying that they have personal knowledge of what's said on the paper, and that they are over the age of 18. They would testify to it in court, and it has to be something that, as we say, if they're wrong or if you find out they lie, that actually is perjury itself, especially when filed with the court. Now, chattel is not cattle. Chattel is personal. So when we say chattel, it can be anything from a cell phone to a car. The way to think of it is everything that's not tied down. Contrast that with real property, and barring the fancy things we can do moving homes now, the best thing is, can you move it? Is it land? Is it a permanent structure? Those things fall under the purview of real property versus chattel. The term chattel is, again, kind of out of use. It is now referred to as personal property almost exclusively. But if you see, there can be cases involving interference with chattel that can be theft. Is a better way of saying it even. So just be aware of that when those terms come up. It could be something very simple that they just decided to make more complicated in the law. You all, I'm sure, are familiar with a county recorder. That's where real property records are kept and deeds are kept. Any sort of lien on a property where somebody says, hey, whenever this gets sold, I am owed a piece of it, things like that. That's where everything's going to be recorded in those offices. Now, probate is the proving court. They handle guardianships, estates, so wills, or people who have passed without a will and testacy. Better way to describe it, the probate court helps those who can't help themselves. And they can't help themselves either because they're dead or they're incompetent to do so. So its concern is distribution and maintenance of property, especially real property. So when you're looking back through, these are great records beyond distribution of estates. It can even be guardianship set up over individuals for their protection, things like that. An attorney in fact, moving on to that, that's a misnomer. See, I'm missing the slide. There we go. Attorney in fact is a misnomer because you don't have to be an attorney. Okay? In fact, most attorney in fact or power of attorney, they aren't attorneys. They're just somebody who has been authorized to act on behalf of someone else, acting as though they were that person. Right? So these can be general or specific. So a general power of attorney, general attorney in fact, is somebody who can do anything as though they were you. You've given them carte blanche, go be me. Okay, you expect them to act and they have an interest, and I'll talk about that in a second. They have a duty to act in your interest. Now, most folks aren't comfortable with that. So what you do instead is you do a specific power of attorney which says, okay, on this particular issue, you get to act as me. For example, my grandparents both had passed away recently, and well, within the last few years, I should say. But they, of course, had property, especially real property, that needed to be sold off, but they had 7 kids. So as you can imagine, it's hard to get all of them grouped up for all sorts of things related to the sale and execution of documents. So instead, each of them signed a limited power of attorney that specifically said that the person, the brother, had authority to act as their attorney for specific parcels of land and the sale of them. Okay, so it didn't just apply to everything broadly, it kept it very, very narrow. And you'll see those a lot of times when you go through. So if you see a power of attorney or an attorney in fact, don't automatically think, oh, this person was an attorney. Most likely they weren't. Somebody who's incompetent is not just somebody who's not good at their job. It's somebody who is not able to make a legal decision. Typically, that would be due to age, could be due to infirmity, disability, anything like that. If you're in a coma, you're incompetent, things like that. So when you see those records, take that with a grain of salt. Same way with infant. Infant does not mean that they're a little baby. Infant just means that they're under the age of 18. So when you see a 17-year-old infant, don't wonder what the heck that means. It just means they're not yet 18. Under the age of majority, that could vary depending on your state and your time period. So if age of majority was, say, 16, then it could be 15 and under. It's just any age under the age of majority. Now, I mentioned somebody has a duty when they're an attorney, in fact, to work on your interest. What that means, they have a fiduciary duty. Okay, so as a fiduciary, you have a responsibility to act in the best interest of the other person. All right. Now, there can be fiduciary duties that an insurance agent has towards you, or that your financial advisor has towards you, where it's their responsibility to work in your best interest. And if they don't, they can be held legally accountable for that. So it's a matter of trust between parties, and that creates a fiduciary duty. Now, a guardian is someone who looks out for the person that they're supposed to be guarding. Okay. So in that situation, we would typically have providing for physical or financial guardianship to protect an incompetent, okay, or an infant, so a minor or somebody incapable of making their own legal decisions. Now, those are general. You have natural guardians. A natural parent and legal guardian is literally just a parent. You're a natural guardian of somebody at that point. However, you can have guardians appointed by the court. Now, those will typically be for special situations. So if you see the term guardian ad litem, that means that there is some special reason the court appointed that guardian, and it's done to protect typically a child and a child's property interest is what you'll see there. So guardian ad litem maintains the interest of the incompetent or the infant and will protect real or personal property, which could include money and everything. A marriage bond doesn't exist anymore, at least in Indiana, but it's something that would be paid just in case there was some funny business going on and the marriage maybe was legally invalid or something like that. It was just like a bond you might think of for criminal right now. It's something you promise, and if it was, say, an illegal marriage, then the county gets to keep that money because whatever. There's a reason it's gone. Now you're going to see a suffix comes up a lot called trix. You'll see executrix or testatrix instead of testator, executor. All that means is trix is a female. So again, that term's not used a whole lot anymore. We try to keep things gender neutral as far as any of the terms that we use. But in older documents, you will obviously see that quite often. But that's all that means. It's not something special. It's just a woman. The term in re, just think in regards to. That's the best way to know what that is. In the matter of is the common use. Some folks still use in re, but again, we're trying to simplify things. And just in the matter of is the best way to look at that. So if you see in re, think in regards or in the matter of. You will see the term cause, and specifically you'll see a cause number. And that is although it looks like a bunch of letters and numbers, typically, it has very specific information for you. So in Indiana, I'll go through an example. You see a cause number, and that's going to be 17 digits with letters. Okay. So the first two is going to tell you what county you're in. All right. So 02 would be Allen County. Then you're going to have what type of court you're in with a letter signifying that. That'll, can be civil or circuit or superior, things like that. And then you're going to have which judge, which court it's in front of. It'll be the judge signifying it. So if it's 09, 03, that corresponds to a specific judge. Next 4 is going to tell you when it was filed. So you're going to have next 2 digits are going to tell you, and let me get this back. Okay, next 2 are going to tell you the year, and then the next 2 are going to tell you the month. So that gives you that information, so you know within at least a 30 to 31 day range when a case was filed. The next 2 letters is going to indicate the type of a case. So we have CT, means a civil tort. You'll see probably a lot of things called PL. Those are plenary dockets, and that's kind of the catch-all docket for things that don't fall into other categories. You will MI just for miscellaneous, and that's for like very small matters that would typically be used. But that'll tell you what type of case it was. So even if you don't have the documents, you at least kind of know, well, hey, this is what's going on. And then after that, it just tells you which case it was in order as it's been filed. So if you see 5 zeros followed by a 1, that case was probably January 1st of that year. So the higher the number, it was that many cases prior to it before that case got filed in that specific year. And a caption just tells you who all's involved. It has the cause number, it has the state, it has the county, it has the parties. Sometimes it'll even list who the judge was. So if you see a caption, that's what's at the top. Property law, property terms, I'm sure have been very confusing for you, and tell you what, they're confusing for attorneys as well. There are very few lawyers that enjoy property law, and I salute those that do, and that's what they practice. For the most of us, it's one of the most confusing, if not the most confusing area of law. And the terms it uses, even today, are archaic and difficult to wade through, especially because so many of them stack up on each other. So I'll run through a few of these. A fee simple, think of it as simple. This is the only thing that's simple in property law. It just means you own it. You own the real property, fee simple. No other encumbrances, nobody else has an interest, anything like that. A survivorship, so let's say 2 people own a piece of property, one of them dies, automatically the deceased person portion goes over, or if the survivorship could be something where the automatically on death without even operation of the probate court, the property passes through a survivorship. Now, there's all types of tenancies. We're going to run through those. You have joint tenancy, where you have 2 or more owners of the real property with survivorship interests, and that can frequently spawn its own litigation. People want to sue each other over that, over how it's supposed to be distributed. You have you have tenancy in common. You have 2 or more owners of the real property. There's no survivorship interest. Think of that as like a 50-50. I own half, you own half. Now you'll see tenancy in the entirety. That is exclusively for married couples, and you have to think of it as each person owns 100% of the property at the exact same time. So it's not a 50-50 split.
Hi. Can you switch
Allison, you are not.
I know. Can you switch to the next slide?
Oh, yes. Thank you. If one of the spouses passes, then it's not like the 50% that spouse owned transfers over. Literally, the surviving spouse already owned 100% of it. So it can be sometimes confusing concept, but it's a way to protect spouses actually, versus going through a probate and having the 50% of the house become part of the estate that then creditors can go after and things like that. So that's why spouses have that special protection. If you partition land, that's where you're dividing up an existing parcel into multiple parcels. So if you own a piece of property and you want to sell half of it, you would partition it and have a new record in the county recorder's office of a separate parcel that you then sell off. So if you see partitions of land, that's what's happening there in those records. A life estate is me telling you, I have this property, I'm going to give it to you, but only until you die. And at that point, it's not yours and it's not part of your estate, so your heirs don't get it. It will either come back to me and my heirs, or you can even say it'll go to somebody else. And that's where all these other confusing things come in. So you have remainders. So it's an interest that after a life estate expires, what happens to the property? Who has the remainder? A revision, or reversion, pardon me, is where you say, okay, you have a life estate, but it's going to come back to me when you pass. That's a reversion or reversionary interest, is that I get the property back. So a covenant, you may all be familiar with. Think of HOAs. Those are promises that run with the land, and what that means is it doesn't matter who owns it down the road. If the covenant has been recorded as part or deed, it is legally part of the land itself. It is part of that deed. Now, these are really, really disfavored because you're restricting what future people can do with their land. Government does not like that, and that's actually what we call the restraint on alienation. Government does not like when one person tells a future owner what they can do with their land, or when somebody else who doesn't own the land what they can do with the land. So for a covenant to be effective, it has to be extremely, extremely clear. If it's not, the court's not going to enforce it. If it's vague whether something would fall under the covenant, it doesn't fall under the covenant. So that's where, again, you see that restraint on alienation. We don't like those. We don't like restraints on what you can do with the property, whether you sell it, whatever you do. An easement, you probably are all familiar with. Your utility companies have an easement on your property for power lines, gas lines, things like that have to run through the property. It's just a legal necessity. People couldn't get power to their homes if there wasn't an easement on their neighbor's property. Power line go through it. So those are what you're going to see, but they're also frequently recorded, so that's good. You would be able to see, okay, well, if there's an easement on this property for a access road, there must have been maybe a home or something down the way. Now, that said, those are only a very, very few terms in property law. Black's Law Dictionary is your friend. Use that. It will be confusing for you, just like it is every. Now, if we move on, we have probate terms. If somebody dies intestate, think of that without testifying as to what they wanted happening with all of their assets. So an intestate person has no will, no directive on what's supposed to happen with their property. And when that happens, it gets distributed originally by common law, now by statute. There's a specific statute in almost every state that says how property gets distributed without a will. Okay. If there is no will, you have what's called letters of administration. These terms do kind of change and are used interchangeably depending on the state you're in. Just be aware of that. Letters of administration or letters of representation, sometimes letters, even those can be used just to show a third party that the court has authorized on behalf of the estate of the person. So for everyone who dies, there is still an estate, but the estate could be through a will or through it being intestate. So if you then, let's say, have an heir or a beneficiary under a will, and you want to give them part of their inheritance before you die, okay? Prodigal son, for example, you give them the portion of their inheritance. That's an advancement on what they would otherwise inherit. So when the say the father gives the advancement to the son, the father passes away, well, the son doesn't get that portion. So whatever the son would have gotten, you subtract the advancement. That's what the inheritance is. So those, however, are never presumed. If the son gets something from the father and there's no specification that it is an advancement, then it's considered a gift and will not count against inheritance. You will see litigation, you will see cases and disputes in your families over whether or not something was an advancement or a gift. Because as you can imagine, siblings sometimes like to quarrel about who gets what, and that is a big area of contention. Now, an heir is someone who inherits from a deceased person. That is typically through bloodline. There are, and the hierarchy of who gets to collect as an heir is set again by statute. If you have a bodily heir, term's not used a whole lot anymore, but that's a blood lineal descendant. So son, daughter, grandson, granddaughter, direct line. If you have a collateral, that's somebody off to the side, like a cousin, aunt, uncle, something like that, where they are still technically a relative and may be able to collect as an heir, but they're going to be secondary to anybody else who's actually in your a direct bloodline. If you see somebody had a failure of issue, that just means they don't have any direct descendants. Sons, grandsons, granddaughters, anything like that. They failed to issue forth offspring. It's a good way of thinking of it. Your issue are your direct descendants. So if you see that term used in a probate context, it's going to be your direct descendants. Sheet or a sheet to the estate, or pardon me, to the state, and you'll get those sheet, state. That just means that there's no heirs, nobody who could be identified that should collect either by statute or by common law, depending on what it was, and that means that the government gets to keep it. So if you will see some cases where they just say, person was a loner, parents are deceased, no siblings, never had a wife, all that property will end up kicking over by default to the estate. Pardon me, to the state. Estates and state, when you're talking about probate law, can sometimes get a little blended, right? So a will also be called, you'll see it lumped in, last will and testament. Remember we talk about intestate, testament being the opposite of being intestate. Okay, you're actually saying what you want to happen. Now, a will is a signed document witnessed by two disinterested persons. So in Indiana, what that means is you have to be over the age of 18 or older, or serve in the military. So if you happen to be under 18 but you're in military service, you can make a will. It has to be in writing, it has to be signed by the person making it, and two disinterested witnesses, so people who aren't going to collect under the will. Has to say specifically that, and you need to be of sound mind when you're making the will. The signatures have to be done in the presence of the person who made the will. So you can't mail it to one witness and mail it to another and have them sign. It has to be done usually in a ceremony type process where people gather and it's an official thing. You go ahead and do it. That way there's at least a little bit of gravity to what you're doing, because it really is important, since you're dictating when you're gone what your wishes are. Now, the fun word called a non-combative will. That is oral, where you just tell somebody. Almost every state prevents those from being valid, and for good reason. How are you going to prove it? Hey, this guy told me he wanted me to have everything. That can get disputed pretty quick. So most states just say, look, we're not going to deal with that. If it's an oral will, we're just still going to treat it like it's intestate. One exception, and you'll see there that causa mortis, that just means it's a deathbed confession, but it's a deathbed will. So on your deathbed, the thing is you don't have time to write it down, but you want people to know what your wishes are, then you can give an oral will. Those are very, very difficult to prove, so you need to have multiple witnesses, things like that, or else it will almost always go back to an intestate succession. A holographic will is not as fun as it sounds. That just means you wrote it yourself. You have a will, you want to write it out. It's a holographic will. Still needs the exact same requirements, though, of the witnesses and everything. So it's really something where it might give a little more credence and buffer the will, validity a little bit more, but it doesn't actually, it's not required or anything, and doesn't have any more lax requirements than a regular will. Now, an executor or an executrix or an administrator or a representative, depending on the language used, is a person who the will specifically designates to execute the wishes of the deceased. So that's why the executor is to take those actions. It's a personal representative is typically used in an intestate situation versus a will. But again, it varies very much by jurisdiction. Just know any of those terms will generally just be referencing, hey, who's in charge of making sure this gets done, and the people who are supposed to be given property get that property. Now, an ancillary, again, not used a whole lot now, but this is someone who is just basically the relief pitcher. It's who is going to be in charge if the executor can't do it. So you pick Bob to be your executor. Bob dies before you do. You never change your will. Well, Sue, who's the ancillary, is going to be the executor when you die. Okay. Always good. This is not legal advice, but I would strongly suggest you pick people younger than you to be your executor. Just kind of a little bit of insurance, at least. Now, letters testamentary or letters of testament, those are documents that, similar to letters of administration, they're basically the same thing, just as that you're allowed to operate, to disperse property, things like that. And when I say disperse the property, if property's in my name but I'm dead, and then somebody else comes along and says, hey, I want to sell this property, I know my name's not on the deed, but trust me, it doesn't really work. So you have to have these letters from the court saying specifically, yes, they're allowed. This is how people access deceased bank accounts, anything like that, where somebody else is going to be like, well, wait a second, why are you suddenly having construction? It's not actually construction. This is where a court will look at whether it be a will or a statute or something and try and interpret what it means. If it's not clear, if there's ambiguity, if anything like that. Now, of course, the risk is the will could be interpreted in a way that the deceased didn't mean, which means that any will, and again, why we're trying to get away from legalese, any will that's not clear and is subject to construction, if it's so unclear, it could end up that the court just says, look, we can't enforce it, and it's just going to be an intestate will. And your wishes aren't going to be honored. So if you see that where a court engages in construction, that will happen when there's a contest, and I'll explain that later, that
there has to be a dispute over the will for a court to ever engage in. Now, a codicil is literally just a addition to an existing will. It does not override the original will. It doesn't extinguish it whatsoever, but it has the exact same requirements as a will. So you still need to have two disinterested persons signed in the present, still be of sound mind, all of that information. Right? So a codicil, that's something that you'll see tacked onto the back of the will when you find it. It could change some of the terms of the original will, but typically if it would do that, then it would just be an entirely new will. Codicils often will account for new property that may have been acquired or things like that that weren't around when the first will was made. A beneficiary is the will equivalent of an heir. They sometimes will still be called heirs, depending on your state and jurisdiction. There's different ways that the property can be distributed as a beneficiary. So if they just generally say, hey, everything I have gets divided among my two children, we'll say that. Well, if one of your kids dies and has two children of their own, there's two ways it can be divided. It could be divided where everybody gets an even split. So instead of your child, your surviving child getting 50%, everybody gets 1/3, both your kid and your two grandkids. The more common way is where it actually runs according to generational lines, and that's where if you have two kids, they're supposed to split 50-50. One dies, leaving two kids. Those two grandkids of yours would split the 50% rather than each getting a third. Can be a little bit complicated. You'll see those per capita, per stirpes. Again, every time you see those, I don't expect you to remember. Run over to Black's Law, take a look. Depending on your jurisdiction, one might be preferred over the other. Just be aware of that. Yeah. The terms legacy, bequest, devise, those are all special legal terms that we really try to avoid. They are very, very common in older documents, so you are going to run across them. A legacy is a way of just saying, hey, I'm leaving this person some money. A bequest is, hey, I'm leaving this person some of my chattel, personal property. So, oh, I have this watch that I want to give to such and such for some reason. And a lot of times they're made with like a little explanation of why you're giving it to them, kind of, something meaningful or something. A devise is, I'm giving you this real property. So they're terms of art that you're going to have to wade through. But realistically, just think all three, I'm given a beneficiary of something out of the estate, is what they are. A residuary or a remainder sometimes, that's going to be your catch-all at the end, where it just says, anything else I haven't addressed, anything remaining in my estate, all goes to Bill, or all goes to my heirs at law. So if it could just go to your kids or something like that, you can leave it open-ended. That way, you don't have to account for everything you own. In fact, your will could just be, hey, I want everything I got to go to this person. The entirety of the, it's a residuary, except it's the whole thing. After acquired property, now this typically will fall into the residuary, but if it doesn't have a clause like that, this is property that you get after you've already made your will that's not accounted for, even if there's another codicil or something like that. So let's say you get this new real property, but you don't throw it in the codicil. All of your real property is described particularly in the will. A lot of times what will happen is that after acquired property gets distributed as though there was no will. So it just goes to heirs at law under the intestate clause. If there is a lapse, it's where a benefit from the will, so a legacy, bequest, devise, they can't collect because they're dead if that beneficiary has already passed away. So it depends sometimes how the will's written, whether the heirs of that deceased beneficiary would inherit or not. when you're going through these records, it's entirely possible that you will find a will saying this property will have gone to Bob, and you think, oh, well, Bob's kids must have gotten it. They may not have, may have instead the property just looped back into the residual estate as the residuary and gone to somebody else who was supposed to inherit under that. So if you're looking at a will and you can't figure out why it's not registered that these people had the property that they should have inherited, it could have gone to somebody else, and you need to trace that back through the will. A pretermitted child is somebody you don't know about. This is kind of the drama concept of somebody bursting into the will being read saying that I'm the long lost son of such and such. It's a pretermitted child where the will does not account for them. And in that situation, if there's sufficient proof that they are indeed the child, there's ways that they can collect from the estate, even though they're not specifically named in the will. That's called election. Election, most often, though, when you see something like that, is going to be where one spouse gets totally screwed over by the other. So if a husband dies and leaves his wife nothing, the election principle will say, I elect to collect what I would have been owed if there was no will. So it's a protection of spouses, typically, sometimes other heirs or children, depending on the situation. Again, that's going to be different every single jurisdiction you run into. So be aware and just kind of trace that through, knowing that it's not always going to be clear who is entitled to get that election or not. But if you see where somebody was supposed to get some property, but they didn't, dig in a little bit, because you could even find another long lost relative through some of that. Now, when you have a contest, I mentioned that before, it's where people are disputing either whether the will actually is valid or what the terms mean if there's an ambiguity. So it's going to be your quarreling siblings who are disputing if daddy left me this or if he left her this. It's going to be where there's some dispute over the advancements versus gifts, like I mentioned before, where somebody says, well, hey, he paid you 10 grand, that was part of your inheritance. And it's like, well, no, he was just helping me out. Those are contests. It's going to result in litigation. Now, most wills are what's called self-proving. A self-proving document, literally just on the face, is what it says it is. It's kind of like self-authentication, because for the most part, if you have a will that's been signed by two disinterested parties and meets all the requirements on its face for a valid will, you don't have those two witnesses come into court and testify, yes, I saw the deceased write this will in his own hand and I signed it, blah, blah, blah. You don't need to do that. Now, if there's a will contest, you may need to have that. So you could actually see, and sometimes it's better for your purposes as researchers if there was a will contest, because in that situation, you'll have a lot more records about it in court filings and things like that. There could even be transcripts involving trials and things like that, bench trials typically. You may need witnesses in those situations. But those are kind of the general terms as far as probate court goes. Now, these are very complex in a lot of situations, especially, again, the property terms. Nowhere near delved into what different fees there are. When I say fee simple, that's one of a myriad of different fees, and that's not like payments you have to make. It's just literally the type of property interest that you actually have. So if you run into fee something else, go to Black's Law. That's the best advice I can give you.